Good morning, everybody. So for those of you who don't know me or don't recognise me, I'm Tabitha Cave. I lead our regulatory compliance team at VWV and lead on safeguarding. And both Natalie and I have been heavily involved in the independent inquiry into child sexual abuse, which I hope will be the last time I say that in full. We'll talk about it as the inquiry or IICSA through this session. We have been involved, as I said, for a long time, for 6 years. First of all, in representing two core participants, but also in trying to distill the information and best practice that has emanated from the inquiry and to share it with our clients. And this session is another to try to draw what we can from the final report that was published on the 20th of October. So there's a short agenda on the screen where we try to summarise the key findings for you, to talk about what the inquiry has recommended, and also to think about what you should be doing now, given that many of the recommendations will require legislative change before they come into effect. I'll hand over to Natalie, who's going to start with details about the scope and scale of the inquiry and the problem of child sexual abuse, and a summary of the key findings. Over to you, Natalie.
Thanks, Tabitha. So as Tabitha said, this has been our life for the last 6 years or so, but the inquiry was actually established in March 2015, and the then Home Secretary was established under the Inquiries Act, and it covered England and Wales. Now, you may have noticed that it went through numerous chairs before the appointment of the current chair, Professor Alexis Jay. Now, the terms of reference were quite broad, and they are set out on the slide, but in summary, they were to consider the extent to which institutions failed in their duty of care to protect children from sexual abuse and exploitation, to consider the extent to which these failings have since been addressed, and as you'll probably hear in this webinar, not enough has been done as far as the inquiry is concerned, to identify further action needed and address any failings, and to consider the steps for which it's necessary for institutions to take to protect from future abuse, and finally to publish a report, which is the subject of this webinar. Now, as I said, it was very wide-ranging. There is no limit to the temporal scope of the inquiry other than being within living memory, and it included numerous organisations in state and non-state institutions, government departments, schools, religious organisations, health services, Parliament. So yes, it looked at all aspects of society. Now, moving on, if we look at the scale of the actual inquiry itself, in terms of the next slide, the inquiry carried out 15 investigations and published 19 related reports, as well as an interim report, and 41 other inquiry reports and publications. Central to the work was the Truth Project and the outreach work. Now, this was a listening exercise which gave more than 6,000 victims and survivors an opportunity to share their experiences with the inquiry and put forward suggestions for change. And you will hear the victims and survivors' voice throughout the report itself. Now, there are lots and lots of statistics within the inquiry, and as Tamar said, these slides will be made available to you. But just to give you an idea of the methodology and scale, the inquiry's public hearings took place over 325 days, and more than 700 witnesses gave evidence. More than 200,000 documents comprising almost 2.5 million pages of evidence were obtained. And as Tabitha said, we acted for a number of core participants, and we can definitely attest to the fact that there was a lot of documentation to go through. Turning to the final report, it was published on the 20th of October 2022, and many of you will have seen our Schools Law brief and lots of different marketing and information we put out about this. Now, it sets out the main findings about the extent to which institutions failed in their duty of care to protect children from sexual abuse and exploitation, and makes recommendations for reform. It sets out the victims' and survivors' voices. As I said, this is key to the report's findings, and makes 20 recommendations which complement the 87 recommendations contained in the previously published investigation reports. As with all the reports, it makes pretty difficult reading, but it is well worth taking the time to do so. It runs to 458 pages, and I do have a copy of it here. It's pretty good as a doorstop. But the 17-page executive summary is more accessible for those of you who want to get to grips with the key finding and recommendations. So moving on to the slide in relation to common themes, the next slide. The work of the inquiry over the past 7 years demonstrates a number of findings, many of which you may have already identified from your areas of practice. Multi-agency arrangements still lack focus on child protection. There's still not enough support available to victims and survivors. And sadly, child sexual abuse is not a problem that's consigned to the past. And the explosion of online facilitated child sexual abuse underlines the extent to which it is endemic within our society. Now, one thing that Tabitha and I have been struck by is the devastation and harm caused by sexual abuse, and that it really cannot be overstated. It is often lifelong, and we've seen victims and survivors coming forward 20, 30, 40, even 50 years after they've suffered from abuse. And as we'll come on to discuss, it's not just a national crisis, but a global one. And this slide, the quote on the slide, attests to that. It covers all areas of the globe, the US, Australia, France, Spain, Japan. They've all had a number of national inquiries into child sexual abuse. Now, the scale of the problem is truly shocking. And again, on the next slide, there are some statistics about this. The fact is that children are sexually abused every single day in England and Wales. One recent estimate described as conservative has suggested that around 500,000 children are abused in a single year. And last year, nearly 70,000 sexual offences were recorded against children in England and Wales. And up to 850,000 people in the UK are thought to pose a risk to children. And if these figures weren't shocking enough, an estimated 3.1 million adults have been sexually abused before the age of 16 in England and Wales. And babies and toddlers and children are potentially at risk, with current estimates indicating that 1 in 6 girls and 1 in 20 boys experience child sexual abuse before the age of 16. I mean, that is truly shocking. And I think what these statistics bring home to us is this is not a historic problem, but a very real one faced by children every day in this country. And even for lawyers like Tabitha and I, who deal with these sorts of issues day in, day out, I think the report acted as a timely reminder at how truly shocking the issue of child sexual abuse was and is. Now, if we move on to the next slide, we're looking at the types of organisations where child sexual abuse can be an issue. And that's why we're so pleased to have so many delegates from all different types of organisations joining us today. Now, this graph helps to illustrate that this is a problem which affects all sectors. Now, the inquiry was required by its terms of reference to refer all allegations of child sexual abuse to the police, and the referrals were passed to Operation Hydrant. Between the inception of the inquiry in 2015 and March 2020, Operation Hydrant received over 10,500 referrals. And as a result, over 100 individuals have been convicted and a further 40 defendants have been charged and are awaiting trial. And this is in addition to those individuals who had already been convicted of offences, and many and the inquiry's work did also focus on those organisations where individuals had already been convicted of offences. Now, I mentioned the online threat at the outset, and I think this next slide illustrates how the online threat is central to the issue of child sexual abuse in this country. Now, we all know that the internet and social media platforms have created new and increased opportunities to offend. And, you know, the internet and the World Wide Web is the wild, wild west, and there seems to be no realistic prospect that perpetrators will stop in their pursuit. It's a national and it's a global crisis. Now, as I've said, the National Crime Agency estimated that some 80,000 people in the UK alone could pose a threat to children online, and this is increasingly through live streaming. Millions of child sexual abuse images can be accessed within just 3 clicks, and you can access live stream of child sexual abuse for as little as 93 pence. Now, the online threat is growing year in, year out. And on the next slide, we can see that there are more than 250,000 URLs which are confirmed to contain images of or videos of child sexual abuse. Now, if you're someone like me that's not too tech savvy, a URL is a specific location where a file is saved online. But what shocked me was that some of these URLs themselves contain thousands of images and videos, and it's a growing problem year on year. Now, the pattern identified in England and Wales is also consistent with the global trend of rising levels of child sexual abuse across the world, and the rise of the dark web plays a big part in perpetuating the online threat. However, what we see on this graph and on the next slide and the following slide are likely just to be the tip of the iceberg. Nearly every one of the investigations concluded that the true scale of child sexual abuse is likely to be much higher than the actual numbers recorded. And this continues to be the case with the current methods of data gathering. This is something that the inquiry wants to address. Not all children will be able to understand what is being done to them amounts to child sexual abuse, and some may not be able to tell someone about it. And this was something that they certainly focused on in the inquiry. If we move on to slide 13, a recent survey estimated that 76% of adults who were victims of rape or sexual assault did not tell anyone about their experience at the time. People were even less likely to tell the police. Only 7% of victims informed the police at the time, and only 18% told the police at any point. And again, this is something that we've seen in practice. Often those who have been victims of sexual abuse will come to the organisation before going to the police. Now, disclosure of abuse is a complex and lifelong process. And often such disclosures don't take place until adulthood. And one shocking statistics that we came across was that the allegations of child sexual abuse in the Roman Catholic Church indicated that it took on average 26 years before such abuse was reported. Now we move on to thinking about what we can do to help and thinking about victims. Now, risk assessment and understanding who is most at risk is key. Whilst it's important to be vigilant in respect of all children, there are some trends which you may wish to consider when working your risk assessments. The inquiry found there were some key factors here. So if we just briefly look at these, gender was a factor, and although both boys and girls can be victims of child sexual abuse, as I said, girls were 3 times as likely to be as boys to describe experience of child sexual abuse. Whilst the data suggested that the greater proportion of victims are girls, there is evidence to suggest that boys may be less likely than girls to report sexual abuse in childhood. Now, age. This was quite a shocking revelation for me. We all know that all children of all ages are at risk of abuse, but younger children are at greater risk. For participants in the Truth Project, nearly 80% of the victims were under 11 at the time the abuse began. And if we look at other factors such as disability in those children who are in residential care, disabled participants were twice as likely to be subject to child sexual abuse, and those who lived in residential care nearly 4 times as likely. There are also those children who may have experienced childhood neglect who were also much more likely to experience child sexual abuse than those who had not. Those children who were part of the LGBTQ+ experienced distinct barriers to disclosing, reporting child sexual abuse, and this is believed to have led to underreporting of child sexual abuse by LGBTQ+ victims and survivors. And again, looking at ethnic minorities, there were thought to be significant barriers to effective reporting of child sexual abuse, including victim blaming and notions of shame and honour. In some religious traditions and communities, children are not taught about sex or sexual relationships, and that's in some faiths and in some languages, there are no words for rape, sexual abuse, for example. And some victims and survivors from ethnic minority communities were in fact removed from school relationships and sex education programs, and so didn't understand the concept of sexual activity, which understandably in turn inhibited disclosure. Now, we've talked about the online threat, and some of the offending involves the rape and violent abuse of babies and toddlers on an unprecedented scale. Live streaming affects children all over the world, including in the UK, the majority of whom are girls aged between 7 and 13 years. And while most internet companies either prohibit or discourage children from under 13 from accessing their platforms, the inquiry repeatedly heard evidence that under 13s will usually easily access their platforms and were at significant risk of being groomed. If we move on to the next slide, as we've already seen, this is not a problem which just affects those children of secondary school age. And in fact, this slide demonstrates the majority of children were abused before they were 11. Shockingly, I read that there have been sharp increases in self-generated images depicting 7 to 10-year-olds, and some self-generated imagery involving perpetrators encouraging their children to involve their younger brother or sister in the abuse. It's truly, truly shocking. Now we turn to the perpetrators. And there was a lot of thought given to whether there was a way of recognising a potential offender or a potential perpetrator. And that's not really possible. There are some really good expert reports, including from Marcus Aruga, which sets out information about different types of offenders and the so-called slippery slope to committing sexual offences against children. However, there are some patterns. So most individuals convicted of sexual abuse, up to 98%, were males. However, it was suggested that this wasn't truly representative and that, of course, female offenders do exist. There were some patterns of behaviour. So often perpetrators sexually abuse more than one child, and their offending spanned years, if not decades. And again, this is something echoed in Tabitha and my practice, that if you have, you rarely get an example of an offender offending against just one child. Many children who were victims were isolated from their carers and families. Some of them were taken away on unsupervised trips and holidays, and particularly around the area of overnight stays. Offenders generally identified vulnerable children who are less likely to have the capacity or capability to complain or protest, often singling out children with disabilities who were unable to communicate what had happened to them. and many offenders befriended the child's family and carers in order to gain access to the child and eliminate suspicion about their motives. They often created a veneer of genuine affection, which not only enabled the abuse, but also inhibited the subsequent reporting of any disclosure. Many offenders plied children with alcohol, drugs, gifts, and affection to create the false impression that they were genuinely fond of the child, and some even threatened violence to secure compliance. And in some instances, we saw physical abuse which was used as a platform for sexual gratification. We also saw offenders adopting a ruse, for example, pretending that they had medical examinations and that kind of thing, so that they could sexually abuse a child. And then we move on to the online sphere, where many offenders pose as children online or encouraged children to live stream content for payment. Now, it won't be any surprise to hear that the inquiry wants organisations to adopt a "it could happen here" approach in terms of understanding who is most at risk of harm and who may be more likely to sexually abuse children. Now, again, from our experience in working on the inquiry, all too often offenders hid in plain sight for way too long. And one message I would say is do not underestimate how motivated offenders can be to avoid detection and what steps they will take to avoid or circumnavigate child protection measures. If we move on to common failures at an organisation level, the inquiry grouped these into three broad themes: failures of leadership, a lack of concern for the child's welfare, and inadequate and sometimes wholly absent child protection arrangements. The next slide sets out details of some common failures and examples of poor practice. So, where an allegation was reported, there were often failures to respond appropriately, with allegations being ignored or not reported to the statutory agents and records not being kept. Often staff were unclear about their role, they lacked confidence in their managers or leaders and did not base their practice on the best interests of the child. Some institutions had no child protection policies or procedures at all, or where they were in place, they were often inadequate or not complied with. Now, one factor that we saw come through quite strongly across the different types of organisations was the fact that an adherence to a particular grouping, often of long standing, often led to an abuse of power, a lack of accountability, and compromised child protection. And deference and obedience in some settings inhibited the reporting of allegations and in turn contributed to the abuse of power by those exercising leadership or authority. In some close-knit communities, such as educational facilities run by monastic orders and custodial institutions, normal scrutiny by parents, friends and visitors was restricted. And I'm sad to say that in many instances, reputation was prioritised over the needs and safety of children. Now, there are other factors, for example, that you may not have thought about. So the external physical environment in some cases presented opportunities for sexual abuse which institutions didn't monitor or supervise. So this included where there were extensive grounds and outbuildings which were frequently misused for sexual activity for children. And too often, people classed as volunteers were allowed open access to children in care without any vetting, thus creating opportunities for potential child abusers. Now, it's evident that child sexual abuse came to the attention of many people in authority in many different ways and at different times, and with widely varying responses, or in some cases, none at all. Organisations shouldn't rely on children coming forward as a sole means of identifying and detecting child sexual abuse. And staff should be trained to recognise indicators of potential sexual abuse and what to do if an individual suspects that abuse has occurred. Now, if we move on to good leadership practice, and hopefully these are some of the things that you already have been implemented in practice in your organisations. So embedding child-centred values and making child protection everyone's responsibility, and creating strong governance and clear individual accountability, providing a visible role model of listening to children and involving them, and ensuring a diverse and inclusive practice. Creating a speak up culture is absolutely key, and gathering good data and making the best use of it. And finally, learning lessons. All institutions involved on a regular basis with children must remain proactive and vigilant. If information about known or suspected sexual abuse is held by anyone in the institution, it must be acted upon, and proper investigation should take place, regardless of cultural, religious, educational, or societal norms and belief. And there should be no exceptions to this requirement. In the vast majority of the cases examined by the inquiry, and many of those we've come across in practice, there have almost always been missed opportunities to prevent abuse. And where abuse has taken place, some organisations have also been resistant to learning lessons from what happened. The reality is that many of you will unfortunately come across abuse in your professional lives, and on the whole, you will be judged on how well you deal with these issues as they arise. So I'm going to pass over to Tabitha now to speak more about the recommendations.
Thanks, Natalie. Natalie started by giving us some detail around what the inquiry considered and its findings. What I want to do is to talk a little bit about the inquiry's recommendations. The first thing to say is within the tome of a final report, the inquiry focuses on 20 recommendations, and they are thematic. And I'm going to take you through the themes and recommendations in a moment. But let's not forget that there are many more recommendations that have been made. So 107 recommendations in total to 33 different government departments and organisations. While the final report contains details and an update and a summary, you may wish to actually go and look at the source documents, particularly if there is an earlier investigation report that's of particular relevance to you and your organisation. Now, I suppose the starting point in talking about recommendations is that they are just that. The inquiry has made a number of recommendations, but they're not yet required in terms of practice. And what I would like to spend the next bit talking about is, well, what has been recommended? What can we expect in terms of next steps and changes to the law? And actually, is there anything that you should be doing now in the context of what we've heard about the damaging effect of delay and the fact that we don't actually need to wait for things to be required before we take steps, if indeed we think they're the right thing to do. Just in terms of timescales, we're not likely to see any significant change quickly. The inquiry has asked every institution at which recommendations have been made to publish details of the steps they'll take within 6 months and thereafter at least annually. And then, of course, we're going to have the government's response to those over time. For all that there is considerable pressure to take quick steps and quick action, I don't think that we can expect a requirement that we do so anytime soon. If we move on to the next slide, what we have here is what Alexis Jay says about all of that. And I think it's a powerful quote. She pays tribute to the victims and survivors who came forward, and she says that we mustn't fail those people, and she herself urges all of the relevant institutions to promptly implement the recommendations they've made, given that it is the inquiry's considered view that they are all designed to protect children from child sexual abuse in the future. I think the next thing just to say about the recommendations is that they've said there's no one size fits all. In this, there's no fix it, and so what they have recommended is a list of different measures which together should improve matters, whilst recognising that we're not going to be able to eradicate abuse completely. So if we move on to the next slide, I'm going to start then by looking at what the inquiry deems their concluding recommendations in the final report. What I've tried to do in the slides that follow is to highlight both the themes and their 20 recommendations to give you a little bit of context. So the starting point is around data. And as Natalie's already told you, the inquiry considers that there is very real underreporting of child sexual abuse, and actually real difficulty in monitoring trends and capturing data, because the data sets vary so much. So the inquiry's first recommendation is to establish a core data set about abuse and characteristics of victims to be able to report on going forwards. The next is in terms of prioritising the protection of children. And you heard about the continued problems with multi-agency working. There were issues raised about, frankly, inadequate cooperation and inefficiencies and delay. And so one of the inquiry's recommendations is to create a child protection authority for both England and Wales, being the two jurisdictions they were looking at through the report, who they want to task with improving practice in child protection, providing advice, so not just the regulatory piece, but an advice piece, and also to inspect institutions and settings. And we've heard so much about problems with the current inspection regimes not identifying poor safeguarding practice. So they feel that this will be an appropriate way forwards in order to better target the protection of children. They've also recommended that we have cabinet ministers for children in England and Wales. So people who are tasked with working across departments to give a voice to children and make sure their interests are prioritised. And they also say that one of the issues that we have about reporting and taking appropriate action in England and Wales is that it's still not clear enough to people about who they need to go to, what's right and wrong, and what to do in the event that you have concerns. And so they want the government to start a public awareness campaign about abuse so that it's on the national agenda, and that we can correct some of the misunderstandings that there are out there about abuse, and what abusers may look like, or some victim blaming that they've seen, and really identify the nuances that those of us who work in safeguarding now understand. Next, they looked at how they may better empower children and young people. They recognised that in the past, adults often thought that children weren't telling the truth when they tried to disclose child sexual abuse, and they've started to think about what that might look like. Now, in an education context, of course, we now have requirements to teach about relationships and sex education, and to give people language to be able to articulate these things. But the inquiries also talked about two particular aspects where they've made specific recommendations. One is about prohibiting pain compliance techniques, which are still used or have been. And the other in relation to care and protective proceedings for children. They recognised that quite often children didn't feel they were being appropriately represented in care proceedings, and they wanted to give them a voice and an opportunity to challenge local authority decision making where they didn't feel it was in their best interests. So those are two further recommendations that that have been made. And if we move to the next slide. So the next theme that we're looking at is one of creating a more protective environment. And essentially in this context, it is a multifactorial theme that was looked at, but they have identified that there are a number of regulatory gaps and they want to plug those essentially. So quite often around plugging the registration and regulation of those who work with children. So they've already talked about the need, for example, to register staff who work in schools with children, such as teaching assistants and learning support staff who historically haven't been regulated. And now they're talking about more to regulate those who work with children in care homes and custodial settings. They also said that they recognise that we've got this powerful children's barred list, and yet not everybody who is employing staff to work with children is able to access that, and they want to change that, and they want to change that both domestically and to make that information available overseas too. They were quite critical of many organisations in relation to what they identify as gross underreporting to the DBS, and in a similar way to the recommendations you will no doubt have heard about in relation to mandatory reporting, which I'll speak about in a moment. They also want to make people aware that it is a criminal offence not to report concerns about the suitability of people to work with children to the DBS. So they're going to be raising the threshold and monitoring of that, given what we've heard. And they've also said we've all got to make sure that we've got suitable child protection policies and procedures in place. And now, and that goes first of all for your own organisation, but also for organisations that you are working with. They're not prescriptive in all scenarios about what that would look like, but are very clear that any organisation, whether it's got a regulatory requirement to have a child protection policy or not, ought to have one in place. Next, they moved on to talk about identifying and reporting child sexual abuse. And what they were very clear about, and it was a piece that Natalie mentioned a moment ago and you may have missed, was that it is not the responsibility of a child to come forwards. Yes, we should all support children and create an environment where they can report child sexual abuse, but it's the adult's duty to identify and report it. And what they were saying in that that context is that we really do need to train people in the signs of child sexual abuse and exploitation. So signs of abuse being knowledge or interest in sexual acts which are inappropriate to their age, use of sexual language or knowledge you wouldn't expect, asking others to behave sexually or play sexual games or have sexual health problems, looking at issues like signs of distress and behavioural signals that might be self-harm, physical injury, personality or demeanour change, or change in daily behaviour. And it might be that a child starts to make a disclosure but doesn't see it through. So these partial disclosures, all of which they were very clear that that people need to be aware of, and what they've seen over time and continuing is an absence of certainty about those signs to be able to report them. They also wanted to talk about indicators of grooming, which Natalie talked about in part. So compliments, special attention, gifts, alcohol, drugs, cigarettes, inappropriately close physical contact, and also that contact with children outside of the professional environment. So we have those, and this also this recommendation that there's much more that we can do by way of technology and technology-based detection, and that we ought to be thinking about online safety and constantly refreshing that as technology advances. And Natalie talked about the amount, the scale of known child sexual images that was identified by the inquiry. And at the moment, although we know that there are a lot of child sexual abuse images, there isn't any pre-screening of that before images are uploaded, and there's a recommendation that that is done going forwards. The one recommendation that has had the most press contact, press interest, if you like, is that of mandatory reporting. And if we go on to the next slide, the inquiry essentially recognised that there is gross underreporting of child sexual abuse, and they looked at some of the factors about that, and they talked about the fact that there can be a number of reasons. It might be a desire to protect someone, it may be a desire to protect a community, it might be imposing some sort of filter about whether it's actually really is abuse, whether it's a finding. It may be really not recognizing the problem at all. And it decided that it would look at other jurisdictions where mandatory reporting has been in place, and particularly Canada and Australia. And what they found was that in all of those jurisdictions where a mandatory reporting duty was introduced, the amount of reporting increased. Now, there are some people who said, I'm not sure that that's necessary, not least that the amount of reports we have already exceed where the amount of reporting you had in those jurisdictions once the duty was there. And also because there's concern that if you criminalize matters and you make it compulsory, that you may deter people from themselves making disclosures or reporting. But in running through the detail of the argument on both sides, the inquiry decided that actually it was appropriate to have a mandatory reporting duty, and that could be balanced with protective exemptions. So they have recommended that we have some legislation, and that is legislation which binds what they call mandated reporters and makes them under a statutory duty to report child sexual abuse to the police or local authority in circumstances where they receive a disclosure from a child or a perpetrator. So it doesn't have to be known child sexual abuse, it doesn't have to be a finding of it, it's just a disclosure of it. Or if they witness a child being sexually abused. And in those two circumstances, then it would be a criminal offence to fail to report it on. But there is also a duty to report observed, recognised indicators of child sexual abuse, and I think we can expect those to be published. And when they're talking about child sexual abuse in this context, they're referring to any act which would be an offence under the Sexual Offences Act, and so can be very widely drawn. That can be issues such as rape and indecent assault. It can be engaging in sexual activity in the presence of a child. It can be meeting a child following grooming. It can be around indecent photographs, sexual exploitation. It's very widely drawn. And if you are on the call thinking, okay, well, who are the mandated reporters? Who is this duty expected to apply to? And what the inquiry has recommended, that it's any person working in regulated activity in relation to children, any person working in a position of trust in relation to children, or police officers. Okay, so if we then go on to the next slide, I'll continue with the recommendations that we have. Recommendations in relation to our justice system, recommending compliance with the Victims Code, and that's around sensitivity and support and keeping people in the loop, giving them information in part, removing deadlines for bringing claims for compensation. And when it comes on to supporting victims and survivors, they've identified real problems with people being offered specialist support in terms of funding, delay, or actually the nature of the support that's there, and have said that child victims must be offered timely and free specialist therapeutic support. They've also talked about a code of practice from the ICO, removing reviewing the retention period for which offences which of child sexual abuse or allegations of those offences, the record should be kept. And they've also talked about that code of practice, including more information about how a victim ought to be able to access those records and ought to be treated when requesting them. So we can expect some more guidance there. There are changes about compensation, so further changes to the Criminal Injuries Compensation Authority and the introduction of a new national redress scheme, so compensation scheme in England and Wales for 5 years. But the proposal is that in a similar way to compensation under the Criminal Injuries Compensation Authority, that organisations that may be legally liable would have to reimburse for any government support that's given in that way. And what they've then said is we must always bear in mind that there are evolving challenges in dealing with child sexual abuse, such as globalisation and technological, difficult to say, developments. And one of the things they're very worried about is the absence of working age verification measures for online providers and social media, and they want that looked at again. So if we move on to the next slide, I want to talk about what you can and should do now. And if we move on again, I want to talk about what our view is on those. So the first is the government is saying we need a public awareness campaign. People don't know enough about child sexual abuse, about the factors that can contribute to it, about the harm it causes. And for me, if there is a general concern about that, then we do have a part to play in assessing and improving our own community's awareness of child sexual abuse. And I've listed some factors on that slide about things that you may wish to consider in that context. And then if we move on to the next, we do need to be able to listen effectively to children and victims. And the inquiry gave quite a lot of guidance through the final report. And indeed, the first half of the report was documenting victims' experiences, in which they've called for people to listen without judgment, to respond with both compassion and respect, to keep careful records, because so many times those records are either inadequate or have been disposed of. To keep them updated, and by them I mean keep the child or victim updated about process, about what you're going to do, to respond when you say you're going to. There's a real call to acknowledge that sexual abuse occurred where you can, and to apologise where you can, but said that some of the mealy-mouthed apologies that victims have received are frankly more damaging than not having been given one at all. So they should be genuine and meaningful. And we are expecting two things that would help with those. One is a government consultation on apologies, and the second is an amendment to the Compensation Act, so that if you do acknowledge that abuse occurred, that it wouldn't be treated as an admission of liability in a civil claim for compensation. And victims said quite often that yes, they want the acknowledgement and the apology, but they also want to know that change has happened or will happen as a consequence. They felt very strongly that they want to be able to protect others from what they've been through. So communication about that can be very useful. They've talked about not relying on current time limits, which is consistent with the other recommendations. And there's also this suggestion that we should be considering offering both specialist report and financial redress, and certainly applying the Victims Code and the Association of British Insurers Code of Practice for the management of abuse claims, which amongst other things recommends that it's only in very exceptional circumstances where you'd ever raise a limitation defence or a defence that a child in some ways consented to abuse, and also talks about really vilifying confidentiality clauses in settlement agreements now. And if we move on again, I do think that organisations should consider their approach and communications about abuse in the light of the report. They should certainly reflect on the report, whether you keep a careful note about that, and how you would do so will need careful consideration. most of you will be doing annual reviews of safeguarding, and that would appear to be a very sensible time to do it, if not before. I think most organisations that we've been dealing with have now undertaken a review of the allegations they're aware of, but if you haven't, you may wish to do so. I don't by that mean an investigation of whether the allegations are true or not, although that may be something that you wish to do, more a review of how it was handled by your organisation and whether there's anything else that needs to be done now. And I think in the past, we focused on allegations or disclosures that were brought directly to your attention. But one of the things that we've seen through the inquiry is how often when abuse was looked into, it was already something that was in the corporate memory or being discussed about within an organisation. And if you haven't looked at those, then that may be something you wish to do. And indeed, some of you may think it's appropriate to reach out to victims and survivors or alumni off the back of the report in order to maintain a dialogue or offer support. And if we move on again, we recommend that you review those child protection policies and procedures that you have. So we do have a requirement for organisations which work with children or whose members may come into contact with them to have tailored policies in place that are clear and accessible and work. Not only for your own organisation, but also for those organisations that you work with who work with children. And more has been suggested about reviewing the pre-employment, pre-appointment even checks that you do, referrals in view of the increasing scrutiny on that, and technical barriers in light of the rapidly evolving framework and ability to track behaviour online, which is a cause for concern. And if we move on again, we'd also recommend that you review staff contracts and codes of conduct just to make sure that they do cover the indicators of grooming set out in the report, and that staff have a contractual duty to report concerns, if not yet a mandatory reporting duty, which sounds as a criminal offence. And I would just recommend that you make sure that that contractual duty aligns with the proposed mandatory reporting recommendation, so it does mirror the wording that that I've shared earlier and the reference to the Sexual Offences Act in doing that, and we'll make sure that that's available on our resources so that you've got ready access to an online version of that. And on again in slide terms. Also, a recommendation that you review the data aspects. So we've talked, haven't we, about retaining documents relating to cases or allegations of abuse. The inquiry at the beginning said keep them for the duration of the inquiry. The inquiry is now finished and we have a recommendation that those records are kept for 75 years. I certainly wouldn't recommend that anybody dispose of what they have now in light of the recommendation that has been made. It may be necessary to review your document retention policy if, for example, you referred to retention for as long as the period of the inquiry. And I'd also recommend that you train staff who are dealing with information requests to enable them to deal sensitively and with empathy for those who may be requesting these records. And one other recommendation that was made along the way of the inquiry was to create a public liability insurance register like we have for employers' liability insurance. That hasn't yet come through, although it's received widespread support. And I would certainly recommend that organisations which haven't already done so do prepare a careful record of your public liability insurance within living memory as being as far back really as you can, so that you have access to who you need to report any claims to, should they be made. Okay, the next slide, please. Just to finish, I wanted to share Sir Peter Wanless, the Chief Executive of the NSPCC's thoughts and comments on all of this. I thought his quote was very powerful. An utter tragedy if Liz Truss's resignation completely overshadowed the report and our opportunity to show victims and survivors that we have listened and we will take action. So he too is calling on the new government to translate the recommendations into a robust system that helps to keep children safe.